there's a lot of, and as you just heard, there's a lot of nuances that go into determining lost profits. And my takeaway is to really do the due diligence and research and not only find the case, recent case law or the Federal Circuit ruling to really understand how it should be applicable to, your particular case facts. But it's really driving down and understanding, how certain things were determined from the Federal Circuit and those specific case facts and the nuances of why it was ruled one way or another in order to determine whether or not that's actually applicable in your situation. Just because, these things are evolving. And so you just want to make sure that as you move forward in determining lost profits damages, that you're really applying the appropriate framework.
Thank you for that response. Jeffrey, do you have any key thoughts you want to leave for your attendees?
Sure. I would summarize my presentation with respect to looking at Panduit Factor 2 as really sort of needing a three-pronged approach when discussing or when evaluating the availability of acceptable non-infringing alternatives. Deconstructing that term to, one, figure out what non-infringing alternatives may be in the context of the patented technology and what wouldn't be accused or what wouldn't infringe in that context. Then looking at whether or not those non-infringing alternatives may have been available on or around the time of first infringement, and looking at it from an availability perspective more than just simply an idea. It has to be something that's operational, something that could have been switched to or manufactured around the time of first infringement or soon thereafter. And then looking at those non-infringing alternatives, the ones that are available, also whether they would be acceptable to customers, consumers in general of the products at issue, because ultimately, even if the non-infringing alternative is non-infringing, even if it is available, if it's not acceptable, you haven't properly supported Panduit Factor 2 and whatever lost profits claim you may be making.
Thank you for those final thoughts, Jeffrey. Robert, would you like to give us your final thoughts as we close out the webinar?
Sure. I would go back to price erosion, and I would just point out for price erosion in particular, it's one of those areas, I think, where the law has come to track the way economists would have always looked at the problem, which is prices affect sales. And so when you calculate price erosion damages, it's important to realize the impact of lower prices on the quantity of units that were sold and the quantity of units to which price erosion damages are relevant. So I think it's one of those areas in patent law where the law has increasingly embodied economic content more and more. And so, working with the experts to try to understand early in the process how to assemble the data that's going to be, or the information necessary to properly evaluate price erosion damages is important to the extent you're going to make those claims.